In this class, we'll discuss a new topic under intellectual property right, and that is patent laws. So, regarding patent laws, we have framed certain questions relating to the provisions of patent laws, and those questions as such as question number 1: what is the meaning of patent? Give a brief account of historical development of patent laws. So first we'll go to the very meaning of patent. So, patent means an official document giving the holder of the patent sole right to make, use, or sell an invention and preventing others from imitating it. Patents are generally granted to inventions. Inventions include both tangible products as well as processes. A person owing a patent over a certain product or process has the sole right to use the product or process. He or she is entitled to pursue a claim against another person using such a product or process without prior permission. In the business world, patents have essentially performed two commercial functions. One is creating a market barrier to other competitors and charging royalties on the license of patents to third parties. Business model patents are a specialized form of patents where claims are made for the exclusive rights over certain processes which are business functions. This is distinct from purely scientific functions that have been the stronghold of patents in the past. A patent is a right granted for any device, substance, method, or process which is new, inventive, and useful. A patent is legally enforceable and gives the owner the exclusive right to commercially exploit the invention for the life of the patent. The legal right is not automatic. One has to apply for a patent. All applications for patents are examined to ensure that they meet the necessary legal requirements for granting a patent. Patents give effective protection if one has invented new technology that will lead to a product composition or process with significant long term commercial gain. One cannot patent artistic creations, mathematical models, plans, schemes, or other purely mental processes. So now we will go to the very historical development of patent laws in the world. So, as per the records available, the history of patents and laws date back to 14th century. So, Italy was the first country to start Vatican Statute of 1474, under which the Republic of Venice issued a decree by which new and inventive devices, once they had been put into practice, had to be communicated to the Republic in order to obtain legal protection against potential infringers. In 1623, in England, followed with the Statute of Monopolies under King James I of England, under which the king's government would issue letter for patent registration to any person with a monopoly to produce particular goods or provide particular services. As per the record, the first of these patent letters available was granted by King's government in 1449 to a famous man, a 20-year monopoly on the manufacture of stained glass. The statute of monopolies was later developed by the courts to produce modern patent law. This innovation was soon adopted by other countries. Subsequently, in United Kingdom, the Patents Act 1977 harmonized UK patent law with the European Patent Convention, and it is no longer based on the Statute of Monopolies. And in case of United States of America, on April 10, 1790, USA President George Washington signed the bill which laid the foundation of the modern American patent system. Since then, the USA Patent and Trademark Office has recorded and protected from the electric lamp of Thomas Edison, the telephone of Alexander Graham Bell, the flying machine of the Wright brothers, to the inventions of hundreds of thousands of other inventors. The patent system has protected inventors by giving them an opportunity to profit from their labors, and it has benefited society by systematically recording new inventions and releasing them to public after the inventors limited right have expired. And in case of India, the patent laws in India, first of all, was under the Act of 1856, and that was during the British rule, just 1 year before the Sepoy Mutiny of 1857, and subsequently that act was further enacted and amended in 1859, just after Queen Victoria took over the administration of British India territories from East India Company directly in 1858. So later on in 1872, the Patents and Designs Protection Act was enacted, and so also in 1883, Protection of Invention Act was enacted by the British Parliament for India. So also later on, the Indian Patents and Designs Act was enacted in 1911. So the colonial patent law of 1911 secured the Indian market to British industry. A large majority of drugs were imported from abroad until the Patents Act 1970 brought a turnaround in India. So, after enactment of the Indian Patents Act 1970 by the Union Parliament, again in 1974, there was a repealing and amendment of the Indian Patents Act of 1970. Then again in 1999, the Patents Act of 1970 was amended, and further the Act was amended in 2002, and in 2004 there was a Patents Amendment Ordinance was issued by the President of India, and to substantiate and to make it a law in the successive year in 2005, the Patents Amendment Ordinance was converted into Patents Amendment Act 2005 by the Union Parliament, and in recently in 2023 the Union Parliament enacted another most important legislative piece relating to business law, or in particular to intellectual property law, and that is Jan Vishwas Provisions Amendment Act 2023, under which most of the offences falling under the Copyright Act of 1957, Patent Act of 1970, the Trademark Acts of 1999, and the Geographical Indication Act of 1999 are being decriminalized, and most of the provisions are rationalized only by decriminalizing and rationalizing those offenses falling under those above acts. Its aim only is to boost business, trade, and commerce in the country. So, these are the historical development relating to patent laws as in context of the world, in particular how it originated in Italy, then how from Vatican to England, and from England to United States of America, and how during the British rule of India substantially the Britishers enacted many pieces of legislations relating to patent and designs and inventions. And finally, the government of India enacted the Indian Patents Act 1970, and further it was subsequently amended in 1974, 1999, 2002, and the 2004 ordinance, which converted as an act in 2005 by the Union Parliament, and finally in 2023 the Union Parliament enacted Jan Vishwas Provisions Amendment Act. So, in our upcoming video, we'll discuss question number 2, which is what do you mean by infringement of patent? Discuss the remedies available to the plaintiff in a suit for infringement, and that will discuss in our upcoming video.